SCOTUS threatens key voting rights protection for minorities. What you need to know. A bold shift in voting rights could be on the horizon. The U.S. Supreme Court has just intensified the redistricting showdown in Louisiana by requesting new legal briefs, challenging whether the deliberate formation of a second majority black congressional district, designed to meet the requirements of the Voting Rights Act, might infringe upon constitutional protections guaranteed by the 14th and 15th Amendments. This new directive, issued last Friday, asks all involved parties to delve deeper into the question of whether artificially establishing a second majority-minority district violates constitutional provisions. The language of the order hints that the court's conservative majority might be preparing to issue a sweeping decision, one that could potentially deem the districting process intended to empower minority voters under Section 2 of the Voting Rights Act as unconstitutional. If the court rejects the idea that the goals of the Voting Rights Act are tied to a compelling state interest, it could severely restrict the ability to safeguard minority voting power in future elections. Historically, the court has shown some leniency. For instance, it has previously allowed states a degree of flexibility when considering race in the drawing of districts to comply with Section 2, as long as race was not the overriding factor. This fine balance is now in jeopardy. To add more context, the controversy submitted to the court did not emerge in isolation. Just months earlier, a federal judge nullified Louisiana's remedial congressional map on the basis that it constituted an unconstitutional racial gerrymander, even though the state legislature had intended the map to remedy an earlier violation of the Voting Rights Act. In Louisiana, where nearly one-third of the population is black, this contentious map was designed to address the stark imbalance where black voters. Supreme Court to consider outlawing race-based voting districts. In a move that could shake up the political landscape, the U.S. Supreme Court has signaled it will weigh in on the contentious issue of race-based voting districts. This decision, expected to be a major showdown, could have far-reaching implications for numerous congressional districts that currently have predominantly minority populations. The justices have agreed to broaden the scope of a Louisiana case already on their agenda, considering arguments that the 1965 Voting Rights Act may no longer serve as a valid justification for deliberately creating voting districts with a majority of black or Hispanic voters. This is a complex issue that has sparked much debate, and it's the part that many people might overlook: the potential impact on representation and fairness in our electoral system. But here's where it gets even more controversial. Could this move, intended to promote equality, inadvertently dilute the political power of minority communities? We'd love to hear your thoughts on this critical issue.